Let's begin. First off, I want to thank everyone for joining us today. We know, it's never easy on a Wednesday at 2 o'clock, 1 o'clock, wherever you are, to join us, but we really appreciate it. My name is Pat Foley. I've been at PUA for the last 10 years, and I'm filling in for my boss, Sandip Chandaranda, who is currently in Mexico sipping some Mai Tais, but you're in good hands. We also have Jonathan Shoemaker and Ken Holland here. They're the real legal eagles that will be handling most of this webinar, but we're in good hands as well. Also, I want to just thank our marketing team and everyone for getting everything out. This is truly a team effort, and without your help, we could not do this. Before we begin, just quick few housekeeping items. Everyone will be muted during this, so there's no interruptions. But if you do have questions, please type them in the chat box, and at the end we will have a designated time for Q&A. And but as they come along, just feel free to just type in at them, and we will get to them. But last but not least, this also will be recorded for us. So if you miss anything, we will send out a link in the next 48 hours that you will receive this full recording. And if you have any questions, there will be a slide where you can email any other questions and we will get to that though. But yeah, let's begin and let's jump into our agenda for today. So start off by giving a quick PUA overview, and then we will go down the list here, dealing with standard of care, dealing with costs associated with new laws and tariffs, the indemnification, prevailing party attorney fees, site safety, conditional payment terms, limit of liability, design build, and then at the end, like I said, hopefully we have some time for a Q&A. Quick disclaimer for you to read. Obviously, this information is not legal advice and should not be relied upon. I want to start off by introducing PUA. So PUA stands for Professional Underwriters Agency, and it was formed in 1990 by Sandip's dad, Ram Chandarana. So we've been, around for a long time, got plenty of expertise. We got that stability and proven track record. Last year, we wrote just over $74 million in gross written premium, which is wild to think. When I started 10 years ago, we were around 15 million. So we're growing. The name's getting out there, and we truly believe we're one of the premier players in this industry. Out of that 74 million, we have over 1,500 insureds, which is a lot. All that premium stems from 4 lines: the A&E, the architects and engineers, the design, build, and contractors. And then we have a miscellaneous program for those one-off risks that, mostly are not licensed A&E or architects. They kind of fit within the construction industry, and that's, the smaller stuff. And then we have our last line is excess limits, which is really truly needed right now with everyone seeing in all these contracts and projects needing, 5 million, 10 million in limits. It's really growing. So how did we get to 75 million in gross written premium? Well, we are the exclusive MGA for Arch Insurance Company, and we have an admitted product and a non-admitted product for that. And then we also are an MGA for Lloyd's, which is E&S. So we got the dual platform, which allows us to be, aggressive in both areas and allows us to adapt on what is needed. We truly like to think we are a one-stop shop, and that is why we enrolled PUA Market Solutions, which is a division where we have 15 other carriers that we have access to, which started as a capacity play, but now it is dealing with retailers that would like to put the business through us because of our expertise, our service, and we've been able to grow that pretty much. With this program, the one true differentiator is Ken Holland, and he is the man, the myth, the legend. He does unlimited contract reviews for us, and when I say unlimited, it is truly unlimited. Some insureds take full advantage of that. He's got a 1-800 hotline for any risk management questions. And then as an added bonus, he does these quarterly webinars for us, and where your insureds can receive CE credits for joining. So he's the man, and he's going to take us away. But there's a library of past webinars on our website at puainc.com, and tons of other good resources as well. So be sure to check that out. Now I'll briefly go over some learning objectives for today's webinar.
So Good afternoon, everyone. The man was kind enough to invite me to join him for today's program, and we have a packed agenda of material to cover. My name's Jonathan Shoemaker, and along with Kent, we are both lawyers who focus on representing design professionals, and as part of that process, we are constantly reading the law. That is, what cases are being decided, what theories are being advanced in terms of claims, so that we're on the cutting edge of what's taking place so that we can advise our clients on those issues and can provide learning opportunities like this to identify from cases that have affected real design professionals and to distill lessons learned from those cases that you can apply to your everyday practice. So that's the overarching program that we're going to be covering today, and hopefully by the end of the program you'll have a better appreciation for why there is such a focus amongst lawyers who work with design professionals about the use of contracts to mitigate risk. The first topic that we're going to be talking about today is the standard of care, and I want to start off with that. If we can move to the next slide. Everyone who's in attendance likely understands what the standard of care is in their daily practice, but as it relates to what that means, you see it in your contract on a daily basis, but I always like to begin these types of programs by defining those terms. And so the standard of care is the ordinary level of care exercised by design professionals practicing in the same or similar circumstances in the same or similar locality. Yeah, so the first case we're going to be talking about takes us out to Chicago and involves the Shakespeare Theater there in town. They were repurposing an outdoor stage to an indoor theater, and they engaged an architect to assist them, and as happens on design projects, there were budgetary constraints. And one of the budgetary constraints led to an investigation of using what are referred to as limited use or limited application elevators instead of full service elevators. During the course of the budgeting exercises, the owner was advised that these elevators would have limited capacity, that there would be long time trips, and the owner, faced with their budgetary constraints, decided to proceed with using those limited use, limited application elevators. After they were installed, as you might imagine, catastrophe happened. On opening night, the elevators failed and patrons were trapped inside this brand new theater facility. After that disaster was mitigated, a solution was needed, and the architect designed a solution, a more traditional elevator, and ultimately invoiced the owner for designing that alternative elevator because that was a change from what their original design was. When the owner refused to pay the architect for that redesign effort, the architect filed suit to collect the fees. As happens when fee claims are pursued by design professionals, the owner counterclaimed for the repair cost, blaming the architect for the not properly advising them relative to the limited use, limited application elevators. The case actually went to trial. Not many cases do go to trial, but this case went to trial, and there was a split decision. On the one hand, as it relates to the architect's fee claim, the court found that the architect had breached its contract because the standard of care provision included a clause that said that the design would be, quote, fit for its intended purpose. And so therefore, because the limited use, limited capacity application elevators were not fit for the intended purpose, the architect was not entitled to compensation. However, on the owner's counterclaim, the owner did have an expert testify at trial, but the owner's expert didn't offer an opinion about what the standard of care required. He offered an opinion about what he would have done, how he would have engaged a consultant. But after the expert left the stand, the architect argued the expert didn't define what the standard of care was, that is, what is required of a reasonable architect, not what this one person would do, but what reasonable architects would do, or a deviation from that standard. And so the trial court issued a split the baby decision. Everyone got to pay the attorneys and no one came away with money. That was subsequently appealed, and this is the decision where the appellate court affirmed the trial court's ruling, finding that the absence of standard of care testimony really precluded the owner from recovering on their counterclaim. Next slide, please. The lesson to be learned from this particular takeaway is that as somebody who's a design professional, you should be able to talk to your clients about what is the standard of care, this mythical concept baked into your contracts. And so you can explain it not just to your clients, but then you can be able to explain it to what it is and what it isn't, and how it doesn't require perfection. So that's a great example to sort of see the importance of standard of care testimony in relation to a claim against a design professional. If we go to the next case, it'll take us down to North Carolina, and this particular case involved the development of a residential subdivision, and in where the landowner engaged an engineer to provide civil engineering services. 4 years later, a potential acquirer of the property expressed interest to the landowner and then reached out to the engineer to inquire about whether or not the property had the requisite water supply, and whether they had performed water flow tests. And the engineer responded in a very short one-line email, which is probably happens in more cases than not that actually go to litigation. Quote, "We will need to model the proposed water mains for the NCDEQ DWR permit, but the fire flow at the dead-end hydrant meets the minimum fire flow requirements at 20 psi. And that was the extent of the engagement between the prospective purchaser and the engineer. In essence, there was no contract, there was no scope of services, it was a simple email exchange. The purchaser closed on the acquisition of the property and subsequently discovered that additional water supply and pipes would have to be installed, and then ultimately sued the engineer for those additional costs, in essence saying, I overpaid for the property because I would have accounted for those additional costs, or perhaps not even acquired the property had you accurately advised me when I was conducting due diligence on this investigation. The purchaser had 3 experts who testified, but none of them were able to offer a standard of care opinion to testify affirmatively that the engineer had breached the standard of care. And when asked under cross-examination where they were reticent to offer an opinion, the experts really talked about, well, we didn't really know what the intended final uses would be, and that is ultimately going to have an impact on the fire flow number. So you really need to know final design in order to have a final answer. And so none of them were able to offer an affirmative opinion on the standard of care. And as a consequence, the engineer moved for summary judgment, which basically says there isn't a dispute of fact in this case. And the trial court granted because the purchaser's experts could not offer that opinion. The appellate court affirmed the trial court's decision on appeal, finding that expert testimony was required to establish a breach of the professional standard of care, and it just was not present in this particular case. So what's the lesson learned or the takeaway here? Really, it's when you're offering advice to non-clients, especially related to potential acquisitions of property, you really ought to be pretty careful. Even in this case where the engineer got off because the purchaser didn't designate the correct type of expert or solicit the right types of opinions, that type of service is rife for miscommunication or misunderstanding, and more often than not can often lead to claims. Our next topic is something that is a little...
Jonathan, before we go to the next topic, I just want to make a couple additional lessons learned just from observation of standard of care clauses. If you have no standard of care clause inserted in your contract whatsoever, courts will not hold you to anything more than the generally accepted standard of care. So if you're silent, you've got a decent standard of care. We get into trouble when we sign a contract with a project owner that makes us have a higher standard, highest standard, or a warranty type situation. Those are uninsurable and they create real problems. So in each of these cases that Jonathan just talked about, it came down to expert testimony was needed to demonstrate what was the standard. If you have something like you shall comply with all laws, codes, etc., and you shall indemnify your client for any damages, well, there's no standard there. You've just created a warranty, and we cannot defend you by putting in an expert to say, well, you met the standard of care, and just because a fire marshal came along and misinterpreted the code, we are okay. So it's really important that you, in our opinion, have a standard of care expressed in your contract and avoid those warranty type clauses. Okay, thanks, Jonathan.
Sure. So the standard of care really looks at what a reasonable design professional would do under the same or similar circumstances, but presently there is uncertainty over the impact that tariffs will have on the construction industry. Kent, do you have any thoughts on what a reasonable design professional should be doing to manage this risk?
Yeah, so just a few thoughts. The next slide, I have a clause here that was put into a contract on like $1 billion project. We are involved in these guaranteed maximum price contracts around the country where a design builder will come in and propose a project for $1 to $2 or more billion, and they do it on a guaranteed maximum price and on a fixed schedule. There's liquidated damages if they don't get it done on schedule, and they can't get any more money if it goes over. I'm concerned about this because of tariffs that are going to be put in place today that are going to cause increased costs, deportation that we know is coming that's going to potentially create a labor shortage problem. And how are you going to get your job done on time when you don't have this full labor contingent there? And how are you going to get it done on budget when your tariffs are increasing your costs? So this clause that we have here is a way to say, look, if the costs go up for these unforeseen reasons, then you're going to give us a change order. You're not going to hold us accountable. So this is just one clause that I've seen, and I've been asking project owners to include this in their contract. Just an idea.
As an additional thought, we're seeing a lot of contracts where the owner is baking into the base scope of services design to budget obligations and value engineering at the completion of construction documents. Mm-hmm. A highly inefficient time for you to be going back and revisiting design decisions. And what I would suggest is, especially in a world where there's uncertainty on pricing, the later into design you're making changes because of fluctuating material prices or labor prices, the bigger risk the owner is shifting over to you. So in addition to what Kent's talking about, I think it's also important to be cognizant of design to budget obligations and value engineering provisions included as part of your base scope of services and trying to qualify those types of terms as well. Our next topic is everyone's favorite. I know everyone became a design professional in order to learn about indemnification, but for those of you who skipped class that day, indemnification in very simple terms is compensating another party for the losses or damages they may sustain. And this particular case takes us up to Massachusetts, and it involves a dam rehabilitation project. The project design required the use of a 30-inch diameter siphon pipe to ensure drainage. This proved to be insufficient when for the actual field conditions that were encountered by the contractor during construction. And as a consequence of that, it resulted in months of delay getting new materials in place, trying to manage the water, and installing additional pumps. The contractor pursued a claim against the town seeking to recover the costs, and the town in turn asserted a claim for indemnity against the engineer based upon an indemnification provision in the party's contract. The indemnification provision required that the engineer indemnify the town for damages claimed against them, quote, to the extent of the negligent acts, errors, or omissions, close quote, of the engineer. The engineer moved for summary judgment due to the town's failure to designate an expert. And the town responded to that saying, hold a minute, the contractor's pursuing a claim against me and I'm just trying to flow through the contractor's claim to the engineer. And so in this particular situation, the jury should be able to infer that this was a problem because it's so egregiously bad and the costs were so significant. The court rejected this argument, finding, and sometimes you gotta love when judges put great language in their decision, to explain the concept of why an expert was needed. The court explained, quote, whether a reasonable engineer would have recommended the use of a 30-inch siphon pipe rather than a wider pipe in the project's drainage system is not a matter to which a lay jury can apply its common sense to recognize or infer negligence. In other words, we're not going to look at the outcome and say it was horrific and just assume that there was negligence. The town also argued that the contractor's expert, that they could rely upon the contractor's expert to prove a breach of the standard of care. The court also rejected that argument. The court found that the contractor's expert merely opined that the 30-inch siphon pipe was insufficient to account for the differing site conditions from what was anticipated in the construction documents. In other words, the contractor was pursuing a differing site condition claim, and the owner was saying, in essence, that the engineer should have anticipated those conditions and designed around them. But the contractor's expert didn't offer any opinions about what the engineer should have done. And so at the close of the arguments, the court ultimately agreed with the engineer and granted summary judgment in favor of the engineer and dismissed the town's claims against the engineer short of trial. What's the lesson to be learned? Well, we recommend always tying any negligence duties that you assume by contract to a breach of the standard of care so that it's aligned with your professional liability insurance. There's a boatload of other pitfalls that can arise with an indemnification provision, but if you're starting off with tying an indemnification obligation to a breach of the standard of care, you're going in the right direction. So the next topic, while the engineer was successful in this past case that we looked at avoiding trial in the last case, a motion for summary judgment where it was granted is typically filed only after incurring substantial attorney's fees. Kent, do you have any thoughts on whether design professionals should include prevailing party attorney's fees provisions in their contracts to mitigate against this risk?
Yes. The problem with the prevailing party attorney's fees clause is contrary to American law. So at American law, each party pays their own attorney's fees. And when you agree to pay another party's fees, you're really making a contractual liability. You've created a contractual liability to pay the other party's fees. That is not insurable. You have a contractual liability exclusion in your professional policy. So carriers will tell you, an insurance carrier will say, strike out that prevailing party clause altogether. And so that may be our first thing we do. I, more often than not now, instead of striking it, I figure if the other parties ask for it, they're probably going to insist on having it there. I like to have a very well-defined clause. So I think the next slide, we have a clause. We'll go to the next slide. There. I like to use this definition. This creates a very objective definition. A court cannot look at this and say, well, you had an $8 million claim and you won $100,000, therefore you're entitled to your attorney's fees. We don't want that to happen. What this clause does, it says, hey, if you sue me, you better win 67% of your claim. Otherwise, I'm deemed the winner and I get my fees. And this is very valuable. This should reduce these overinflated contractor claims against designers. I've had situations where there was no definition in the contract and I had to settle a case because it was an $8 million claim. I felt comfortable I could litigate it and defend all but about $300,000. But the other firm had 3 very expensive attorneys on their side, and I'm the only attorney on my side being paid by the carrier. And if I lost $300,000, my client would have had to pay, who knows, maybe $1 million in attorney's fees. But there was no insurance that would have covered that $1 million. So it forced us to settle that case where I could have done better if it had gone to litigation. And I've had other cases similar to that. So we don't like prevailing party clauses at all, but if you have to have them, at a minimum, put in an objective definition. It doesn't have to be exactly like this one, but it needs to objectively define who is a prevailing party.
As a negotiating strategy for trying to get prevailing party attorney's fees provisions out of your contract because of the insurability issue, I will often try to use some common sense, and that is practical experience tells me that when you have a prevailing party attorney's fees provision, that can be a barrier or an impediment to settlement or resolution. The last case that I had that went to trial with a prevailing party attorney's fees provision, months before depositions began, there was a mediation that was unsuccessful, and the parties got really close. And following that, I received a weekly email from opposing counsel telling me that their settlement demand was increasing by that week's litigation fees, which grew very tiresome after several months. In the middle of trial, after the flaws in their case were exposed, the owner ultimately made a decision to dismiss with prejudice their claims against my client with no settlement payment from my client because they were more concerned about losing the attorney's fees on the back end. But they had foregone a very reasonable settlement agreement because they became so enamored with the notion of not just recovering their actual damages, but trying to recover their attorney's fees. And when you tell that type of a story, it can be really persuasive in terms of understanding how it can actually be an impediment to resolution rather than to facilitate resolution. Our next topic is one of my favorites and involves site safety. Our first case takes us down to Texas, and anytime I come across a case that involves a bean manufacturing plant, you better believe it's one I'm going to be focusing on. This bean manufacturing plant brought in dry beans, soaked beans, cooked beans, canned beans. They had pipes running over this entire facility, beans in hot water, beans in cold water, you name it, they had it. Probably also some salt just to make sure it tastes good. But on this particular project, the owner hired an engineer to create a conceptual layout for the design of this new facility over a decade ago. Following the engineer's delivery of these concept plans, the owner failed to return any comments and the communications between the parties ceased. The owner proceeded to complete the engineering and the construction of the project with different entities based on a different layout, and the facility opened in 2014. Fast forward 3 years later, they were selling so many beans they wanted to grow the facility. And so in between 2017 and 2020, the facility doubled in size, without the original engineer being involved. So they're not involved in the final facility that's designed and constructed. They're not involved in the expansion. Fast forward to 2021, an employee sustained serious burn injuries in the processing facility and ultimately died when they were operating a forklift and it ran into a pipe filled with beans and hot pressurized water that blasted him to death. In the wrongful death suit, the employee's estate asserted claims against the original engineer who prepared only a concept design that was never used for construction, alleging that the engineer breached the standard of care because there were concerns regarding the height of the pipe, installation protocols, and design defects. The concept plans at issue prepared by this engineer were clearly marked issued for design and, quote, not for construction. And there were no specifications as to the pipe height or other safety requirements either for the construction or operation of the facility. This poor engineer who probably got paid next to nothing for this concept design in the grand scheme of things ultimately moved for summary judgment, arguing that hazard assessment and construction fell outside of the scope of their agreement with the owner. And when the court looked at this particular argument by the engineer, they focused on both the engineer's conduct and its contract. And as to its conduct, the trial court found that there was no genuine dispute that the engineer was hired merely to make a schematic concept design of the facility, plan understood by construction professionals not to be a final product, and he didn't have any further involvement on the project. And as to the contract, the trial court found that the engineer's scope did not include responsibility for any instructions or protocols as to the safety of the facility's fixtures, including pipes. And so the trial court granted the engineer's motion for summary judgment and dismissed the claims against them. What's the lesson to be learned here? Design professionals can be found liable for site safety standards that fall outside of their contract based upon their conduct. And so this case illustrates how courts will look both at contract and conduct to determine whether or not there's potential liability to a design professional associated with a site safety situation. Staying in the South, our next case takes us over to Louisiana. This particular project and case involve a vault demolition that was taking place as part of a construction project where the structure, the vault that was being demolished, collapsed, and the worker who was involved and in the vault, unfortunately, sustained neck and back injuries. Due to workers' compensation laws, the worker was limited in who they might be able to pursue a claim against, but they ultimately filed a suit against the project architect, alleging that the project architect failed to uphold responsibility for maintaining site safety. If we can go to the next slide, the premise of the liability claim against the architect was this particular clause that we're looking at here. Basically, your standard vanilla AIA, I'm going to come to the site and I'm going to look around on occasion and I'm going to observe what the progress of the work is and see whether or not it's generally proceeding in accordance with the contract documents. The architect's position was, I also have another clause, another provision. If we go to the next slide, it says, I'm not responsible for safety on this site. I'm not in charge of what the contractor's doing. And I don't have responsibility for this type of thing. At the trial court level, the trial court looked at the particular claims and granted summary judgment in favor of the architect, a win for the good guys. Unfortunately, this was reversed by an intermediate appellate court, and the intermediate appellate court inferred responsibility from for site safety merely because the architect's contractual duty included performing site visits. Well, fortunately, common sense prevailed because it got appealed again to the highest appellate court in Louisiana, who reversed the intermediate appellate court and said the trial court got it right, finding that the terms of the architect's contract were neither unclear nor ambiguous and specifically disclaimed responsibility for safety precautions in connection with the work. And so as a consequence, the personal injury claims against the architect were dismissed, and that dismissal was affirmed. What's the lesson to be learned from this particular saga? It is just as important for the contract to say what you will do as what you actually do. If you have a contract that disclaims responsibility for site safety, that's going to be the best frontline defense you can present to try to get yourself out of one of these personal injury claims. And as you're probably aware, it's these personal injury claims that have significant and catastrophic damages figures tied to them that drive insurance premiums. So any way you can get out of them and not be contributing to the terrible statistics of adverse outcomes in personal injury claims is a good one to have.
Jonathan, let me just point out something before we go to the next topic. So all these decisions that we're talking about here today, you notice that these are motions practice. So somebody's going to court, they're making a motion to dismiss, a motion for summary judgment. You don't like the result, you appeal it, you get an appellate decision, you don't like that appellate decision, you appeal it again. Now, this is what's excellent about litigation, and I like litigation, and I've come to the point where I do not like arbitration. So arbitration, you could have a great contract clause, but you get arbitrators and they might just ignore the contract and do something that you go, how in the world did that happen? But you can't appeal it. You can't do anything about it. I've had contracts where I have had excellent contract clauses on like limitation of liability, where I'm able to go in, make my motion, court grants my motion, I'm out of there with a $25,000 preliminary dismissal. And then I've had the same client in a different state where they didn't put that clause of litigation in the contract. It said, we'll arbitrate. And I'm like, I called the attorney for the plaintiff who was suing us. I said, hey, we've got this great contract. It's enforceable. And he laughed at me. He says, no, this is arbitration. It won't be enforced. We'll see you in arbitration. And he's right. That's what happens so often. So I really prefer litigation for all these reasons, that we get to go through all these excellent arguments that Jonathan is explaining how well they work.
So, I will echo Kent's comments about preferring litigation over arbitration. Hopefully we can transition from the really dark topic of personal injury and site safety cases to something a little bit lighter, getting paid. Our next topic deals with conditional payment terms. Kent, what's a conditional payment provision, and do you have any thoughts on whether design professionals should include these terms in their contracts?
Yeah, so conditional payment would be like what we call a pay if paid clause or a pay when paid clause, meaning that if you're a subcontract designer working for perhaps a prime architect, or maybe you're working for a general contractor, design builder, the clause says you don't get paid until they get paid. I don't like those clauses, but often if you're a sub, you don't have a lot of ability to get out from under that clause. So you agree to the clause. But I've had situations where my design sub-consultants had to keep on working on the project month after month without getting paid. He had no ability to stop work. So I like to just add a clause like I show in this article, this slide here, saying, look, if payment of an undisputed amount isn't paid within 45 days, then we're going to stop our work. We're going to give you a 7-day notice, and we're going to stop our work. And that way, even if it is a pay if paid, they still have to either pay you or you're going to walk away from the project. And so I just think this is a pretty important clause.
One of the things at the common law in most states, that is the law if there's not a contract, is that payment is a material term to any contract. And so if someone's not paying you, you have the right to stop work. But if you agree to a conditional payment term which says, I'm not entitled to payment until this event occurs, and that event takes a long time to occur, your ability to suspend services in the manner that Kent has just described is just impaired by the very contract language you've agreed to. So including appropriate language or qualifiers on conditional payment terms as a sub is a good practice. Of course, as with all things, I wouldn't be a lawyer if I wouldn't take the other side of the argument. If you're a prime, you've got to have conditional payment clauses or your subs are going to run you ragged. So it's a perpetual debate, and I don't believe there's ever going to be a right answer for everyone. Our next topic is our limitation of liability provisions. I hope many of you include limitation of liability provisions in your contracts, but do courts actually enforce these provisions?
Absolutely, they're enforceable. So the issue is, if you're a commercial entity, most of your contracts are going to be with another commercial entity. So a court is going to look at two commercial entities and say you both had the ability to be represented and have a good contract, and they'll enforce it. If you're negotiating a contract with mom and pop, then maybe not. But what I like to do in an LOL clause is I like to say your liability is going to be limited to your fee, or maybe several times your fee, or maybe to a dollar amount. But I don't like a clause that says your LOL is going to be limited to your fee or $25,000, whichever is less. It ought to be more. Okay, and so I've had courts that have enforced the clause because the court looks at it where I had a $2,500 contract to do an environmental site assessment, and the court looks at it and says, well, you gave them a $25,000 LOL, that's 10 times your fee, that's very reasonable. So these are enforceable. One key is do not mix it up with an indemnity. Indemnification, a court will take a harder look at that, and sometimes people will mix and match, and they'll say, well, you're going to indemnify me and limit my liability. Don't put them in the same clause. And one other thing about the LOL clause, very important that you make your LOL apply to every conceivable cause of action. If you say it's only going to be for your negligence, the court might say, well, they're suing you for breach of contract, therefore you didn't limit your liability for that. So I like to say it applies to your limitation, your negligence, your breach of contract, warranty, everything you could think of, every cause of action you can think of ought to be stated in that LOL clause.
Another sort of concept within the a limitation of liability, we often see design professionals limit their liability to their professional liability insurance. I'm sure everyone who's on this program understands how your professional liability insurance operates, but let's say hypothetically you have a $1 million policy and you spent $200,000 defending against the claim. You really only have $800,000 left to settle the claim or pay a judgment at that point in time. And so one thing you should be cognizant of is if you're negotiating a limitation of liability tied to your insurance policy, is it tied to the insurance policy or the amounts available to you at the time of settlement or judgment, or is it the insurance coverage required under the contract? Sometimes you may have coverage in excess of what's required under the contract. So giving thought to how you draft and characterize your limitation of liability language and provision is going to be critical. It's also important to know that limitations of liability, every state has a slightly different perspective on these. Most states are going to enforce them. But we've actually seen some decisions recently where the inclusion, California, the inclusion of a limitation of liability provision may be construed as an intention of carelessness and be construed against the design professional in some way, shape, or form. So it's always important to understand the law of the states in which you're working when you're entering into contracts. Our last case that we're going to talk about today, and then we're going to have time for questions, is perhaps my favorite. This is a design build case, and it's my favorite both because it illustrates all of the worst qualities of design build that you hear horror stories about when you're reading E&R. And it also illustrates the uncertainty that is litigation. So this particular case takes us out to Colorado, and it involves a transportation project. And a fight was brewing between the engineer and the design build contractor. Ultimately, the engineer, who had performed in excess of $5 million of ad services on the project without compensation, filed suit against the design build contractor. who, filed a $250 million counterclaim. No big deal, right? Well, those are some pretty significant dollars. And design professionals are used to taking their time, developing a design, going through the schematic design process, then the design development phase, then construction documents, so that you get to a measured outcome. Well, in this particular case, after all of the discovery has taken place, the parties file a variety of pretrial motions. One of those motions was what's called a motion in limine, which is a motion that seeks to limit the type of testimony and evidence that can be introduced to the jury at trial. Here, the engineer and the dispute focused on a cost overrun claim by the design build contractor. In essence, they said, you gave us certain quantities and estimates and information during the bid phase that we developed a guaranteed maximum price on. When you actually developed the final plan, the actual cost of constructing your final plans was astronomically higher, and therefore there was a significant cost overrun. On this design build project, there were two separate contracts. There was a teaming agreement that governed the pre-award services, and that teaming agreement included a standard of care provision that included an ordinary standard of care provision, but it also said that the services would be, quote, adequate and sufficient for bidding the construction of the project, close quote. That was probably not the best language to agree to. Fast forward, the project gets awarded to the design build team, and the design builder's project services agreement with the engineer includes a standard of care provision that omits that language about the services being, quote, adequate and sufficient for the bidding language. The contractor alleges that there was a horrifically flawed pre-bid design concept that was only discovered after award, and the engineer, not wanting to have this terrible language from its teaming agreement introduced in front of the jury, sought to prevent the design build contractor from introducing or referencing the teaming agreement standard of care provision, arguing that the project services agreement included an integration clause and superseded or trumped the standard of care provision in the teaming agreement. 6 days before trial, no more time to plan after the 6 days, the ruling comes down. And the motion in limine filed by the engineer was denied. The court found that the teaming agreement and the project services agreement referenced distinct services, and that the order of precedence and integration clauses in those contracts applied only where there was a conflict between the two, and there was no scope of work under the project services agreement to provide bid phase services, so the jury could hear all of the evidence related to the standard of care provision with that language that their services would be adequate and sufficient for bidding the construction of the project. The lesson to be learned is that you really want to be harmonizing your teaming agreement and design agreement. As a quick postscript, though, on this particular project, it went to a 17-day jury trial, at the close of which resulted in a verdict in favor of the engineer on its $5 million fee claim and against the design builder in its totality on the counterclaim. So it turns out that this motion in limine, even though it was denied, didn't come back to bite the engineer in the butt too hard. But there was a prevailing party attorney's fees provision in this contract, and since the verdict, there's been ongoing motions practice related to trying to recover where the engineer was seeking to recover in excess of $17 million of attorney's fees. If you like the idea of floating $17 million of attorney's fees, you can give Kent or myself a call. We'd be happy to give you a help. But I think we've got some time for some questions if anyone has any questions they'd like us to field.
Before we go to questions, let me just make one more comment on design build and the teaming agreement. So it seems like the last almost 10 years, almost all the litigation I've been involved with has been design build. And that's where really the big claims are. So the idea when design build came along, we thought this was going to be the answer to everything. It was going to reduce the claims. Well, the reality is the claims are even bigger, and contractors are your client. If you're a designer, you're working for a design build team of contractors, and a contractor gives us guaranteed maximum price project quote to the owner, and when they don't get as much money as they thought, they're going to just come right after the design subconsultants routinely. And so what I've been doing in my teaming agreements, I have a clause that defines preliminary engineering services, and it sets a standard of care saying we're not giving you final design, we're not giving you construction documents, we're giving you preliminary design, and it's your responsibility, Mr. Contractor Client, to go out and do proper contingency, do all the all the real true nitty-gritty, figuring out how much quantity, how much everything you need. And so that way, if there is a claim against us, we want that teaming agreement to stand up. We want the court to enforce that. So we may even put a clause in there saying this teaming agreement has its own limitation of liability, which is going to be smaller than the LOL for the final agreement, and that is going to be enforceable by the courts. And it's really important, and there have been cases that have enforced that type of a teaming agreement. Okay, let's go to the questions.
So someone submitted a question. For those of us entering into contracts with government or other owners who have their own contract forms, there's a take it or leave it type attitude that many people have. And there are a couple of questions. One is should we be qualifying our proposals even if that's the perspective or attitude of the agency, the public entity? And is there any current or recent litigation finding these contracts to be illegal? I'll try to unpack that as easily as possible. The first is, if you are submitting a proposal on a public project, we always recommend our clients include some type of qualifying or hedging language, even if there's not an express requirement to identify any exceptions you may have to a proposed contract. Even including a clause that says, we anticipate signing a contract that would be consistent with what's covered under the insurance. That in and of itself can sometimes give an opportunity for negotiation. And if the public entity or agency is not willing to bend, there still may be the possibility that your proposal is incorporated by reference as a contract document within the contract, or you might be able to get it attached as part of the contract. So sometimes there may be ways to backdoor language that you can't negotiate on the front end. As it relates to the enforceability of indemnity provisions, they vary dramatically from state to state. ACEC, I know, and to a lesser degree, at least in our neck of the woods, AIA, but both organizations have been active across the country pushing to obtain duties to defend or litigate legislation making invalid certain types of indemnity obligations and certain types of defense obligations that may be found within an indemnity provision. And in Virginia, by way of example, I was actually asked to come and speak to a group of government procurement agents who don't procure AE contracts all the time to help educate them about professional liability insurance and how some of the provisions in their contract were actually undermining the very coverages that they wanted to have, and they just didn't understand that. And so it can be difficult to piece that together, but what's really important is whenever you're doing work in a state or jurisdiction is conferring with a lawyer who's familiar with the statutes in that jurisdiction and the case law that may help to inform the enforceability of a particular clause. In Virginia, by way of example, there's a flat prohibition on duties to defend in AE contracts. And in Virginia, the courts, if a contract clause is invalid, the entirety of that clause gets thrown out. And because duties to defend are frequently found within indemnity provisions, including a duty to defend, which is oftentimes included by agencies who don't know what's good for them, they're actually asking you to sign up for an unenforceable indemnity provision. So it's sort of an example of why it's important to understand the law of the jurisdiction in which you're practicing.
And it looks like a question is presented for us on the question of do we have any drafting pointers concerning drafting a bifurcated indemnity clause so that the duty to defend that Jonathan is talking about won't apply to a professional liability claim, but it could apply to a non-professional liability claim. So indeed, we do see bifurcated indemnity clauses, but not as often as we used to. It seems like parties now just have one big clump of clauses that apply to everything. And what we prefer to do is we will just leave the clause as it is. We won't try to break it in two and make one clause for general liability and one for professional. We'll just say where it says we're going to indemnify, hold harmless, and defend, we'll put after that word defend, we'll say except against professional liability claims, so that we're agreeing to defend general liability claims, but not professional, because there is no insurance for that defense. And then we say we're only going to indemnify to the extent caused by our negligence or willful misconduct. Willful misconduct's not insured, but negligence is. The problem that we see is too many articles of contracts say you're going to indemnify for all damages arising out of your performance. Well, that is no good. The courts will say arising out of does not require a nexus or a connection between your action and the damage. So we strike that and we say no, arising out of is no good. It needs to be to extent caused by. And the other thing we like to do is we don't like an indemnity clause that's so broad that it might have you indemnifying your client for their own first party damages. So a clause often will read, you're going to indemnify and hold harmless your client against claims, damages, losses, demands, expenses, causes of action. They have all these jumbled up. What I like to do is strike all that out and say we're going to indemnify them against third party claims, demands, causes of actions, proceedings, and then I'll put paren, quote, claims, close quote, and then I'll say, and the damages, losses arising out of those claims to the extent caused by your negligence. That way, your client can't come in and just say, well, I lost money on this project, and you've got to indemnify me, or I had to pay more money to put in equipment that the fire marshal maybe do, and you've got to indemnify me. No, not unless there's a third-party claim. And Jonathan, you've litigated cases about this whole issue between third party and first party, and you've done very well. You had a D.C. case where the D.C. court said, yeah, a broad indemnity clause only still means third-party claims. But there are other courts in other states that say, hey, if it says broad indemnity, then you've got to indemnify them for first party. So any other things you want to say on that, Jonathan, before we end today?
I think that your comments there sort of echo the importance of understanding the laws of a particular case or jurisdiction. You know, the cases we reviewed today highlight the importance of careful contracting to manage risk, and Kent and I can probably talk all afternoon about it, but I think our time is up, and I understand that there will be any remaining questions will be fielded separately, but Kent, I appreciate the opportunity to spend an afternoon with you.
Well, Jonathan, thank you so much for putting this together. You were just excellent today, and I really appreciate you joining us. Thank you.